Well, hello everybody, and welcome to the first of what we hope will be many BALPPA webinars. Today this one is being given by myself, Melvin Sandell, and Sue Dearden, one of our lawyers from Finch Consulting. Many of you will know us already, and we are a company that provides engineering, safety, legal, human behaviour, audio and so on services to industry generally and to the leisure industry in particular. So today we're going to talk a little bit about post-accident oblique crisis management and how from a legal perspective you can best defend yourselves and the actions you can take to make sure that the effects of that are mitigated so far as possible. So what we're going to do today then is to follow an incident through from the incident happening and how we would advise you best to handle and deal with the prosecutor and how to best represent your defence. So for the purpose of this, I'm going to pretend to be the prosecutor and Sue is going to act as a defence lawyer.
I am indeed, but perhaps before we sort of mention the scenario that we're going to talk about today, accidents are by definition unexpected events which can happen at any time. And before we talk through a fictional accident, I think it's important to say that you should try and plan for the worst and prepare for it. Make sure that your risk assessments take account of what might happen and how you will respond. An accident doesn't mean you're going to be prosecuted. It means, of course, that it's evidence that you may have failed to take reasonably practicable steps, but it doesn't necessarily mean that you have.
Of course, in this industry, though, don't forget, Sue, that in the industry we're talking about, the leisure industry, most incidents are going to be fairly high profile. Most incidents involve the public and children at leisure, and so they are going to pique the regulators' interest. There's going to be media interest in all of this.
Of course, but
it's going to be high profile.
Yeah, I have advised in a number of cases where, including fatalities, where it's looked really serious and it has been a nasty accident, but there hasn't been a prosecution because the business has actually got everything right and all its ducks in a row. My point is, an accident doesn't necessarily lead to a prosecution. It will mean that there will be an investigation, but one doesn't necessarily follow the other. And if you've got your ducks in a row in advance of anything happening, that's going to be better.
No, you're absolutely right. The point you made a minute ago, the offence is failing to control the risk. The offence is not having the accident. So firstly then, for today, we're going to suppose there has been an accident, and it doesn't really matter what that accident is, but for today, we're going to say that there's a long wooden bridge which goes over a valley or something in your park, and a child, 7-year-old girl, has fallen through the fence or got over the rail or whatever and has fallen 10 metres or so down below.
Are we going to kill the little girl today?
I think we'll allow her to stay alive today, but
okay.
But let's assume that she's got some fairly serious injuries there. So it's likely that this is something the regulator will be involved in. The ambulance has come, she's received treatment on the scene, and she's been taken away. So this is the scenario that we're going to kind of run through today. Now, the way these get reported to the regulator are numerous. They can hear by the police, they can hear from social media, most often by RIDDOR, which will allow you a couple of days leeway, a couple of days grace as the defence lawyer.
Absolutely.
To get there.
As soon as an accident has,
go first.
Yeah, absolutely. Yeah. As soon as there has been an accident, hopefully you've got an incident plan that clicks into place, which will help people to not have to think on the ground about what needs to be done. There will be a number of steps that are set out on which people have been trained. You know, although you know that it's a serious incident, an investigator is going to come in, there will be consideration of criminal charges. And not just against the company, but against individuals too, potentially, if they were responsible for key decisions. But it's easy, and I often see people become almost immobilised by fear of the consequences. We can't do anything, the investigator's coming in. Go on the defensive, close ranks a bit. That's not helpful. You can't turn the clock back. The accident has happened. There is masses that can be done that will help you to avoid prosecution, even now, and that will help you to mitigate if you are prosecuted and convicted. So, a few priorities first of all. Do you know who will be responsible for the first few priorities? If you've got a large site, it's helpful to divide it up so that wherever the accident is, there is somebody who is identified as being the person who will take charge. The first thing to do is assess the scene. Make sure that nobody else is going to be put at risk by whatever the circumstances are, including the people who are going to the little girl's rescue can't be put at risk, really. So you need to assess the scene, protect others. You obviously need first aid as a high priority, and call the emergency services if required, which might include the ambulance, it might include the fire service, depending upon what rescue equipment might be needed. Ensure they know where to go. Hillsborough being the classic case of where they didn't know where to go and ended up the wrong end of the football field, unable to get to the injured persons. Somebody should be on the site who goes to the entrance to direct them to the right area. Look at having barriers that you can erect very simply to surround an injured person on the ground. With these days of social media, you have people who whip out their phones straight away, and it's fascinating to film somebody injured on the ground. Protect them with some barriers. You need to have board engagement right from the beginning. Health and safety needs to be led from the top down, and it's prudent to have someone involved run the board at the outset, and it's good mitigation, good evidence of taking things seriously if you can show early leadership in this situation. And you need to line up an internal investigation. Don't wait for the HSE. Otherwise they will take the lead and you'll be on the back foot all the time. You need to find out what has happened and take steps to make sure public confidence is restored and staff confidence is restored as well. And you ensure that what's happened can't be repeated. So first steps in the investigation will be identifying relevant witnesses and relevant documents, which you ring fence so that they can't be adjusted or amended in any way, which does happen. Take photos of the scene if you can to preserve the circumstances, the weather, the circumstances prevailing at the time and what the scene is. And think perhaps at this stage, depending on the circumstances, of retaining an expert to have a look at equipment that's failed or may have failed. Even at this stage, think about instructing a health and safety lawyer, a specialist in this field. Apart from anything else, mindful of the health and safety executive powers or local authority powers, it's prudent to collect documents together, and to do so when you're creating new documents in particular, to do so in a way that protects those documents from disclosure, which you can only do with a lawyer because that can create privilege for the documents. So early legal support and a tailored communication plan for dealing with the incident. The lawyer can give you an early indication of what offences might be under consideration. You may not be able to avoid that, but you can certainly manage how serious they are and how seriously they're viewed by the court. Think about setting up a daily conference call to review your actions, what you're doing, how you're responding. And if the note from that call is kept by a lawyer, that's then privileged from production. But beware emails. Emails get circulated, copied, forwarded, and they're generally disclosable. So avoid emails that can be taken out of context. You might also want to think about media support, specialist media support, to monitor what's being reported, deal with press inquiries. So you may have an internal marketing team, or you may use external people. The sooner they're involved, the better, to help you with the strategy. You need to notify the accident under RIDDOR, and that avoids commission of a separate offence for failing to notify the accident. You need to notify your insurers. If you fail to do so, that can be a breach of policy. In this case, it would be a public liability policy. And if you fail to notify, they can then refuse to indemnify. So that's an important stage. And make sure that all the people who are involved in looking at what's happened are coordinated and by a point of contact, and everybody knows who that point of contact is. Don't alienate staff by keeping them out of the loop in all this. They need guidance about what to do if the press contacts them, for example. They need to know what is likely to happen next, what's being done. Make sure that witnesses in your staff have information to know by whom they may be interviewed, what their rights are. We do have crib sheets that can help with this, that we can easily ping out to you if you're in that situation. But try and discourage discussion amongst staff about what's happened or what could have happened, and speculation, because you then get fake memories being acquired that they really genuinely believe in but aren't real. So don't underestimate how that can escalate. And keep supporting the injured party or the family if you can. Help them with practicalities, things that generally wouldn't be covered by a claim, things like transportation, helping them with funding for cover for other children at home while they're going to visit their ill child in hospital, or funeral costs, or there are things that can be done which aren't, it's not going to be seen as blood money, it's not going to be seen as compensation, it's just, being a bit human about it, really, recognising they're a family in distress, you're somehow part of that distress, and you can help. And all of that can swing into action even before the regulator has visited the site. So Flip is now going to take us through what a regulator will be doing.
Okay, so the regulator obviously will hear about this either through RIDOR, through the police, through social media, or whatever. It's very likely they will hear about it, but generally not for the first couple of days. Unless it's something dreadfully serious like a child fatality, it will generally take a day or two. So you will have the opportunity to get together with your specialist health and safety lawyer to get the things in place that Sue is talking about. So get your defences in early. Now the HSE will want to secure the scene when they arrive on site. They want to make sure the risk has gone away, and they can do a number of things to do that. I'll talk about the powers in a minute. They will also want to gather as much evidence as they can while it's fresh and while it's still close to people's minds. So this will be the main thrust of their activity on site. Now, just a brief bit about the powers. Sue, you know these, and the audience would have heard me talk about these before. They can give verbal advice, they can give written advice. Then there are two enforcement option notices they have. So the first one requires people to change the way they do things. The second one, the prohibition notices, requires them to stop doing the thing they are doing in the way they're doing it and find a safer way.
Yeah, and if those notices are served, you've only got a very limited window of 21 days from the date of service to appeal those notices, and they do get appealed, and there's a good rate of success in those appeals, but failing to comply with those notices, whether or not you're appealing them, would be a criminal offence.
No, absolutely. I agree absolutely. And as soon as the HSE give you any advice, verbal or written, or any enforcement, verbal or written, pass that over to your lawyer straight away. There are restrictions on what you can do with that, how you can appeal it, how you can use it. They know them, you don't. Involve them as early as you can in every circumstance. So the HSE is there first to find out what happened, second to see if there's any information that can be shared with the wider industry, and third to gather evidence. The most important of those, as far as the HSE is concerned, is obviously the latter. They have a very clear duty to bring any breaches of law, to investigate and bring any breaches of law to court. So from the minute they arrive on the scene, they are investigating the incident. These people are not your friends. They're there to do a job of work. So just accept that.
We try and pretend you're our friends, though.
I can perhaps pretend.
Important to show we're cooperative.
I never tried. but okay, so they are there to do a job of work, and
yes,
that's gathering
absolutely.
the evidence. Okay. In certain circumstances, if it's a more serious accident, the police may turn up first, the HSE may turn up first. Generally, the police will want to hand matters like this over to the HSE as soon as they're content there's no evidence of gross negligence. Manslaughter, be it on the part of an individual or the company, they will generally hand this to HSE. So the police's interest will be limited for as long as there's no fatality in there. But you must be aware that the HSE's duty is to investigate to the full powers, to the full extent they can, and then to punish or to give the courts the opportunity to punish anybody who can be proven to have breached the law. That's what this is about. Don't forget what this is about, and keep your lawyer fully informed and on track all the time they're there. Having said that, the game is not all theirs. There are rules they must comply with. Health and Safety at Work Act, Police and Criminal Evidence Act set rules for the way the investigation is conducted.
Yeah, they don't always follow those rules, do they?
They do. I followed them assiduously back in the day. So that's the sort of my perspective for the immediate aftermath, but then my investigation will go forward from there. So I am going to, as part of my investigation, as quickly as I can, look out and gather whatever information I think will benefit or could have benefit to my investigation. I have an extensive range of powers which lets me take what I want. And within reason,
yes.
within reason, I will gather and take whatever I think will be applicable to the investigation going forward. And I don't know at this stage where the investigation will take me, so I will gather as much as I can, just in case I need it later, so it's still fresh, it's still clean, and it hasn't disappeared. Tricky, unreliable creatures, defence lawyers. Okay, so I'm going to take statements as soon as I can, and I have 3 options for statements. I can take voluntary statements, I can take compelled statements, or I can take statements under caution. We'll talk about the latter a bit more later because this is a particular interest of Sue's, but generally statements are taken under a voluntary basis. And again, there are rules about who can be there and about how they're taken, so speak to the defence lawyer about those at an early stage as well. I'm going to be looking through all of your documentation, all of your health and safety documentation, technical documentation, through your computers, through your IT systems, and I will bring along my specialists when I'm doing this as well. Sue will be advising you to get your own independent specialists in place as part of your investigation. I'll be bringing mine as well.
We've already got our independent specialists in place, and so our experts have already had a look at the equipment because it may be taken, which is one of the reasons why on the defence side you need to get in early.
It may. So I'll bring my specialists along, and just be aware we haven't spoken about FFI. It's a different talk. But fee for intervention, if it's the HSE involved and you are deemed to have committed a material breach of law, FFI is chargeable for every HSE inspector per hour.
And it's appealable.
But the HSE will charge you for every hour of their time and charge you at full cost for any outside specialists they bring in to look at the case.
Provided there's a material breach.
Provided there's a material breach, as I said at the beginning. Yeah, okay. So now, PACE interviews are the thing many people fear. They can be intimidating. They can be a bit oppressive. Sitting in a room with a tape going, knowing full well, having been cautioned that your words can come back to haunt you in court, and you are in a situation where you can incriminate yourself. So they're a bit intimidating. And Sue will give you the defence lawyer's view of whether you should attend. You're only ever invited to attend. Sue will give you the defence lawyer's view about whether you should or not. From the HSE perspective, they are a way to confirm information they have got elsewhere, or perhaps to help them fill the odd hole in the evidence that they already have. They can't be used as a fishing expedition, but they can be perhaps used to confirm suspicions and to help the HSE or the regulator
build a case.
To build a case and to understand a bit more about what happened. And it's not personal, please. Many people take this personally. It's not. The regulator is required to follow all reasonable lines of inquiry. If that leads to you as a manager, if that leads to you as a director, if that leads to you as an individual, that's just the way it goes. It's not personal, Sue.
Oh yeah, okay. So from the defence perspective, there is this requirement that the inspector behaves reasonably and takes what is reasonably needed and pertinent to the investigation. So from a defence perspective, you need to do as much as you can as quickly as you can before the HSE or the local authority start binding you and stopping you from doing things. You need to really mobilise that investigation, manage your documentation, make sure that the copies are taken of the documentation, not originals. I don't think we've spoken about this before, that you took original documentation, but a lot of the inspectors I've come across do, and they don't leave copies either, and then it's like extracting teeth to get the information back again.
You'll know that the HSE's powers don't enable them to take originals. They're only empowered to take
Though they
copies.
do. They do in practice, they do. So hand over copies rather than originals if you can. Certainly keep copies. Make sure that all the potentially relevant documents are preserved. You are entitled to interview staff before the HSE start interviewing, and even while they're interviewing them. And they've got a duty to cooperate with reasonable inquiries as to what has happened. But when the HSE are interviewing, you've got no right to sit in that interview with them, though the individual can elect to have somebody sit in with them, particularly if it's a voluntary interview where actually the individual can almost dictate terms. I will do this statement if I can have this person, if I can have a copy of it. Sometimes they will allow the individual to have a copy of their statement. They will not generally allow the company to have a copy of the statement. The statements, though, if they go to the individual, can often be handed over to the company. You need to be looking right from the beginning at mitigation, as well as your systems and processes, and investigating what has happened and generally around the incident.
I think another worthwhile piece of advice here, Sue, as well, is that remember that the regulator throughout this is writing everything you say in their notebook. So guard your language. Just, as I said at the start, these people are not your friends. They're there to do a job of work, and they're writing down everything that you say.
Yeah.
So guard what you say. Offhanded comments, little things that you might think are witty quips, could come back to haunt you later.
Indeed.
Be professional in your dealings with them, in the same way that they'll be professional in their dealings with you.
Yes, yeah, that is good advice. The interviews, when they do escalate to what we call PACE interviews, which is a reference to the Police and Criminal Evidence Act, and it's a way of interviewing, they are only supposed to be conducted not to plug gaps or find out information, but in order to put charges, the suspicion of an offence for which there should already be the information to convict, to you, to see whether or not there is a defence that needs to be taken into account in making the decision.
The wonder of PACE interviews, Sue, is that once they get going, then the regulator can follow.
Yeah, which is why we don't let them get going, particularly with companies. Individuals, anybody under PACE interview has the right not to attend, not to say anything. The one thing that you need to do with a PACE interview is put forward any defence that you later want to rely on, because if you don't do it at that stage, it can count against you. But, failing to say something isn't not cooperating. You have an absolute right not to attend a PACE interview. For a company, I would normally say, don't send somebody along, because the investigators go off at all sorts of tangents. They don't just ask about the accident, they ask generally about procedures, they go down all sorts of avenues. And it's quite difficult, actually, for one representative from the company to have all the knowledge that's necessary to deal with all aspects, unless it's a very small business and it's a one-man band. I would normally say, put what you want to say in writing so that you have cooperated, and put forward any defence that you might later want to rely on, but you don't actually expose yourself to the interview. You'll be doing your accident report, and you don't want to be defensive in that, or too quick to try and reach conclusions about blame. This is far more about investigating what's happened and preventing it from happening again, rather than who has been responsible. Point fingers too early and it will come back to haunt you. And while all this is going on, keep your staff on board, keep them informed within reason, and keep the family supported as well.
Okay, so we've got to the unfortunate situation now where it looks as though the regulator is going to prosecute you. Now, they prosecute for two main reasons. The first is because this is what their duty is, this is what they're required to do under the law, to investigate the incident and bring any evidence of breach of the law to the attention of the court. And the second then is to give the public and the court the chance to exact retribution on the company if they have been seen to fail to control a risk which has put other people at risk of harm. But just because there's been an accident in your premises, just because you were to one extent or another to blame for this, if there is no evidence that you failed to control the risk so far as was practicable, you're not guilty. Normally the decision to prosecute is taken by a principal inspector, but if it's a big thing with fatalities or children seriously hurt or injured, generally the decision will be given to the court as to whether there's enough there. So it will just go and allow the court to decide.
So to what extent is your decision, or the decision of the principal inspector, influenced by what the family think of the injured person?
It's not. There are two tests. There's the evidential test and then there's the public interest test. Whether or not the family think it should go or not is pretty much immaterial here. The HSE is not working on behalf of the family. The HSE is working on behalf of the state, on behalf of the court and the justice system. The family get a chance to make their representations in the victim witness statement or something like that. Statement. But the regulator will not or should not take notice of the family's wishes. So there are target times for these sorts of things, but they often get skewed by coroner's courts perhaps, or by the difficulty getting witnesses and so on and so on. So in theory there are target times, in practice they often get knocked to one side. And you just must accept that these things can literally take
years.
1 year, 2 years, 3 years or longer to get to court, and it's a stressful time for the person who's perhaps sitting waiting to see if they can be prosecuted.
Yeah, certainly my experience is it does take years.
It can take years. It can happen very quickly, but generally the bigger the investigation, the more complex, the harder it is to get it to court in any reason.
There is no time limit on when you can bring a prosecution, of course, and there are more things that can be done in mitigation. So, for example, in the background, if it's one that you're in trouble on, you might want to resolve a civil claim for compensation, so that as part of your mitigation, you can say that the injured party has been looked after and compensated.
Yeah, I think that's probably fair. But the HSE is held hostage to the idea of being accused of abuse of process if they allow it to drag on too long and if they're too slow in collecting them. So they want to try and push it along, but obviously there's often it's not in their gift to do that. Now, one of the ways it can be sped up, obviously, if you feel that you are guilty of the offence, having spoken to your defence lawyer, a guilty plea hurries things along, and it's to everybody's benefit. It gets the case finished for you. The courts are very pleased that you copped an early plea, and they give you a significant discount off any sentence for that. Third off, absolutely right. And HSE would prefer a guilty plea as well, because it saves an awful lot of work and time and effort for them, which ties an inspector up when they could be off doing other things. But speak to your lawyer. Everything's to play for here still at this stage. Until you actually get to the court, everything is still to play for. So speak to your lawyer. There may be benefits to you in doing this, especially if you are in fact guilty.
It's a sort of common misconception that your choice is guilty or not guilty. There are in fact hybrid positions that you can reach on a plea, where you may be guilty but not on the case that you're advancing. So very common as an example of this is that yes, we are guilty of a breach in some way, but that hasn't caused the accident that occurred. That's quite common. Or there can be some dispute on key facts. So you can put in a hybrid plea. We're guilty, but
not as guilty as you say we are.
Absolutely. Or in a different way that's somehow less of an issue.
It's always less, isn't it?
And that will lead to a court hearing, almost like a mini trial, on whether or not the court will accept your version of events. So that's not a great position to be in, because there is too much sort of risk surrounding that. You can agree an alternative position with the prosecutor, and very commonly now, when cases are sentenced according to court guidelines that fall into tables, and there are brackets of sentence that are going to be given depending upon culpability and depending upon harm, you can agree the bracket in which the case falls with the prosecutor and present that. So if you're going to court, the prosecutor without agreement would normally be arguing very high or high culpability. I'd normally be saying no, it's low or medium. But if we can agree medium or high medium, from our point of view, it might manage this risk for you. And the difference in brackets is substantial. It's hundreds of thousands of pounds quite often, so it's useful to have an agreement on that. It
is, and the regulator is obliged to put forward the most appropriate charge, and generally this will be the highest, the sort of the most serious charge that they think they can prove. But even then, all is to play for. As Sue just said a minute ago, the harm and culpability can bring the fine levels for that down, can bring them down drastically. And I can't emphasise the value of a good lawyer enough. Having prosecuted regularly in my time, I've seen the most bizarre decisions come out of courts where people have been absolutely hammered for what I thought was a fairly light offence, and then have been let off for what I thought was a desperately poor management of workplaces. There's a lot in the mitigation. There's so much in the way the case is presented to courts. The value of a good lawyer, simply cannot be underestimated. Overestimated. Yeah. Just one other thing really from my perspective here is that the regulator is not averse to publicity for itself. The HSE is there to do its job, to bring the guilty to court. It will play to the gallery. It will make it clear that it thinks that you have been punished sufficiently. So if you're worried about publicity as a result of this, then you have to think about that. The regulator is not going to care how sore you are.
Indeed, and I've had cases where I've agreed what statement is going to be issued, which can also help to manage the language that's used. Because the Health Safety Executive will normally issue a press statement. Not everybody is amenable to negotiating on that, but some are. When you're looking at being sentenced for these offences, I've mentioned the sentencing tables that do apply, and the court is obliged to look at aggravating features and mitigating features, and I think it's a common error by defendants to just look at mitigation and not look at what's going to be argued against them as an aggravating feature, because there's a lot that can be said to, just because a prosecutor's arguing something's an aggravating feature doesn't make it so. The one statutory factor that has to be taken into account are previous relevant convictions, relevant being the operative word there. If your defence lawyer is equipped with the information about any previous enforcement notices or any previous convictions, then they can distinguish them and so avoid them taking you up a bracket in sentence. So do think about those and spend as much time looking at those and bringing those down as you do mitigating factors. Mitigating factors vary depending on the case. A good health and safety record is a useful one to bring fines down. The level of cooperation that a company has provided will be taken into account. Having effective procedures in place and being able to demonstrate that generally the company was getting it right. There may have been an issue on this one occasion or in this one circumstance, but generally you're getting it right, will all be done to take it down. But the biggest discount that anyone can receive is an early guilty plea, which I think we've mentioned is third off. And then there's a sliding scale according to another guideline, which means that it will drop down to nothing if you're at the point of trial and changing your plea to guilty. Just remember that your fine and your prosecution costs are not insured, and they are intended by the courts to punish. The wording used in the sentencing guideline is that the fine must be sufficiently substantial to have a real economic impact, which will bring home to both management and to shareholders the need to comply with health and safety legislation. So it is intended to be punishment. It isn't covered by insurance, so it does come off the bottom line, and fines, regrettably in excess of £1 million, particularly for businesses with higher turnover, are now regularly given by the courts. And don't forget that in this process of investigation and prosecution, individuals as well as companies can be prosecuted and may also need representation and support, and in addition to a fine they will be facing the possibility of prison as their sentence in these cases.
Okay, Sue, so I think that's come to the end of our webinar to an extent. So just points to remember then. Any company would be naive to think that it's not going to have accidents. And it also would be naive to think that occasionally those accidents aren't going to be biggies. So you need to plan like you plan everything else for this, and have some preparation in place, at least have an idea of how you would deal with this and who you would speak to, and how you would set in place the things that you have to do. To start with, don't forget that just because the regulator is coming, it doesn't mean you're guilty, it doesn't mean that you've committed an offence, pardon me, and it doesn't mean that you can't put your case in a way that's beneficial for you, and so the regulator will understand the way you did things and why you did things the way you did things. As I've said before, a good safety lawyer will help you out with this and help you articulate and present your argument to the regulator in the best way to help them and help you and the investigation goes forward. It's crucial that this is seen to be led by the CEO level, director level people. The regulator will think greatly or think better of you if the board is seen to be involved in this, and the court will also think better of you if it's clear that the company is fully involved in the investigation, finding out what went wrong and why. Then the court will think better of you, the regulator will think better of you. So make sure that if it wasn't the case to start with, it certainly is during the investigation. Don't forget the family and the staff here. The family are crucial to you going forward. Your reputation with them goes to social media, goes to the media at large. It's important that the family are very heavily involved in your thoughts here, as is your staff. Your staff are your greatest asset and can be your greatest liability. Your staff are the ones that have had to deal with the aftermath of the accident. They may have seen the fatality, they may have had to deal with the family, but these are the people that have got to go to the pub. These are the people whose pictures will be in the newspaper. Look after your staff and make sure that you ensure that they are healthy and well and stay fit, and their well-being doesn't get affected by this, by the incident. And then finally, when you come to court, the court will want to know what you've done to stop this happening again. Accept that this was partly your fault to one extent or another, and that you put in place measures, and you can reassure the court that you've put in place measures to make sure this cannot happen again. This will be part of your mitigation, and it's also mentioned in the sentencing guidelines as a mitigating feature to prove that it won't happen again. Do you think, Sue, that covers?
I think it does.
We should.
Between us, we've.
Okay.
If there are any questions, though, a slide should now come up which gives telephone numbers and email addresses. So we'd be happy to help with any follow-up questions.
Certainly, and thank you all for tuning in today.
Thank you. Bye.
Bye-bye.